Scott, it looks like you and Ms. Krusich either are or were in a relationship,
We dated. We don't live together. Never have lived together.
but you dated.
A little bit. Yes, Your Honor.
And both she and Ms. Gogan work at DSHS.
Correct, Your Honor.
Okay, as do you.
Yes, 30 years.
Okay. And are you in their supervisory chain of command?
Can I explain that to you, Your Honor? So, I work for the Office of the Secretary. Mrs. Gogan, she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where where the problem lies, is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, she sent these memes and information around to the office. And if you see the one that I sent you, where it says in there, do you see who's on there? And I'm a coworker. Where she says, dude, I wouldn't normally message a coworker, but I can't stop laughing. So here it is in this office where you're the admin assistant to the second highest person in our administration. And now how am I supposed to work with you every day and trust when you're discriminating and doing all these acts of inappropriate behavior in the workplace? Mm-hmm. And so part of my action is I'm probably going to file a lawsuit against her. And so I need that protection for me, because per our policy, this administrative policy, she's probably going to lose her job because of that. She even the words that she uses, where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. And then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes.
Buckle up, guys. Today we are diving into a case where hurt feelings turn into legal battles. We meet a man who is furious that his coworker is making fun of him online, so he decides to drag her to court for a protection order. He claims these memes are ruining his workplace trust, but it really looks like a bruised ego. He reads out the text messages that broke him, but trying to make it illegal to laugh at someone is a bold strategy. Let's see if the judge thinks a mean meme counts as harassment or just a tough day at the office.
Itself, and then I'm the senior administrative officer there. I'm third from my boss in the department. I've been working for DSHS for 30 years, Your Honor. I've attained my MBA. I have a HRMS background. I have a Sigma SME. I've been in the Army 20 years. Currently, I own my own business. All these things that she's doing affect me greatly. And it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number 3, actions that violate this policy aren't limited. Violations via phone, email, text, social media, electronic communication. Such behavior can also be outside of work. It specifically speaks to this in our administrative policy.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So
okay, and what about Ms.
So let me finish this. Please, let me finish Ms. Gogan. So I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are putting photos online without the permission of
who's doing it?
are we dating him too? It's a site it's a group that's embedded into Facebook. And currently I have with this attorney generals to take that website down because they are putting males photos up without their permission. And there are women who are on there that are anonymous. So you don't know who it is. It could be any bandwagon person like Ms. Dogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. There's not, it's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where it's very, very libel and slander. So I'm working on doing that for that website. Mrs. Krusich, she was upset that I stopped dating her, and I sent her home one night. And then here, when you're looking at a couple of those, her first posting, she tried to be anonymous and said that this guy was trying to get me to go to work or to blah blah blah, and I sent the photos on there. It didn't look like I tried too hard to get her there. She looked pretty happy there. And then currently, not only does she work for DSHS, but she also has a few things of mine, and she's saying things that are disparaging on that website. And now she has her name on there, and she's identified me where I work, which is very slanderous. I'm currently in my position. I'm in the Army Reserves. I'm also a voting member for BHR in Olympia. And she knows several of those folks. So here it is, you're saying slanderous and libel things, and I could lose that spot, which is a very coveted position for me to be on a voting board here in Olympia. It took me a long time.
One of the things we don't do with the protection order process is keep people from saying bad things about other people. It's their First Amendment right. And so I get this all the time from people who say, you wouldn't believe what they say about me. None of it's true. And they post it on social media. They broadcast it to the world. They call me a pedophile. They call me this. They call me that. And we say, sorry, we can't do anything about that.
I agree with that, you know.
So
I
don't know how I can do something about this.
For me, it's work. I have to.
Right. But that's.
Ms. Goldman can't come.
No, I understand your position. This is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens to her?
Well, we can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. I don't know if I'm pronouncing it. Yeah. And same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy, and for doing so, here's the sanction, whether it's whatever it is, firing or loss of pay or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate procedure. You can file civil lawsuits against some damage
that's coming. Yeah,
that's you feel has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit, but this process isn't meant to address that. So you're not going to get any, what we would call a remedy out of this. I can't give you anything that will address it. So, I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear, I'm not saying that what you're having to deal with is too small for this or anything. It's just, this is not the appropriate process for that.
Oh, that's fair. For me, it's about exhausting all my needs.
Yeah.
So
no,
it's not an end all for me. It's just another bullet in the process for me.
Yep. I get it. certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are black males that are like me that have been dealing with this on these websites. And that's, I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there. But I'll find it. I will.
Okay.
I'm persistent.
All right, guys, the tension is rising. After the narrator absolutely roasts the plaintiff for being thin-skinned, we get to witness the ultimate credential flex. This guy is not just a coworker. He is an MBA, a Sigma 6 holder, and an Army veteran, and he wants everyone to know it. He lists his resume as if his degrees somehow grant him immunity from internet jokes. He truly believes his high status makes him untouchable, but the internet is undefeated. Watch as he claims that a pending lawsuit is about to drop like a bomb on his coworker.
From, I believe it was last week, that the out of custody pretrial, because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the that term.
Could you repeat it?
Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay,
And I don't understand.
sir.
I don't understand. So like the charges would be dropped.
If you successfully,
If you did all those
you have
terms,
to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions? I didn't really get all I really spoke over. What we went over was the terms.
we had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time, and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are. I can
I'm just
tell,
asking
I can
questions.
tell you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
So let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date?
June 2nd.
June 2nd at 8:30. And it will be May 23rd
Yes, sir.
at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time.
Here we go with the wildest turn yet. The plaintiff is paranoid about a Facebook group and thinks he is the victim of a grand conspiracy involving the Attorney General. He is terrified of losing his seat on a voting board, but the judge is not having it. In a savage moment, the judge delivers a reality check about his dating inadequacies. It is a brutal takedown that dismantles the idea that the court is here to protect your reputation from bad dates. If you do not want people talking about your dates, maybe do not date your coworkers.
165992. This is LBNB Funding LLC versus Jennifer Moore. The matter is before the court, settling for a motion. Counsel, your appearance regarding this matter, please, sir.
Thank you, Judge. May it please the court, I am attorney Richard Grusin, and my bond number is 35222, and I am the attorney for the plaintiff.
All right. It appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right. And do I have Jennifer Moore on the Zoom?
Yes, good morning, Your Honor.
All right. Thank you, Ms. Moore. Good morning to you, ma'am. All right. And it appears that the plaintiff is moving. That's right there. Yeah. Well, no, I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Now, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVNV funding when I checked my credit score. And that's how they were able to reach out to me. They were sending information to a different address. And according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail and so on. So, and I reached out to the creditor and they said that they gave my account to Midland. I have since resolved the issue with Midland and it is paid. I then reached out to LV. They failed to give me all my information document needed. And now we're here. So I apologize for not appearing in court when I was going through my difficult times in life, but I am here.
I do see the following response, sir.
I'm not sure how to respond to a lot of that stuff, Judge. I can tell you that I have been retained as the lawyer for LBNB funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that, period. Judgment was already taken against her. And so the case continued. I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument that, quote, the matter that's before Your Honor was with Midland funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
this case was argued. I'm not done, madam. The case was continued to present. And so here we are now with good.
Mr. Rosen, I'm stopping you. I'm stopping you because your device is breaking up, and that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad, and so you're going in and out. You indicated the last thing that was clearly heard was that you prepare to offer a satisfaction of judgment. You said only about $89 or so was owed.
Exactly. Yeah, that's right.
After that, we weren't able to hear you very clearly.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment, well, I'm prepared now, to file a satisfaction of judgment because it's all paid. I have no idea what Ben is otherwise arguing about, but on that I rest.
Well, for the rest of Your Honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LBNV Funding, and that's it. This is not a case that went passed around the room like last year's potato chips. It's a one-time assignment from Credit One Bank to Midland to LBNV Funding. Midland Funding is not involved in this, and I do not represent Midland Funding.
Listen closely because school is in session. The judge has to explain the First Amendment to a grown man who thinks insults are illegal. The plaintiff tries to play the victim card again, confusing wiretapping laws with reading mean comments, but the court shuts it down. It is painful to watch him grasp at straws, while the judge explains that you cannot sue someone just because they are laughing at you. This is the final nail in the coffin for his case, proving that while words might hurt, they are certainly not a crime.
Right, thank you, Counsel Pam. I'm back to you this morning.
May I? Yeah. Thank you, Your Honor. And I agree with you. I also reached out to the original creditors. That's why we're here now, Mr. Rosen, because I did reach out to—
That's Rusin, ma'am. Rusin.
Oh, many apologies, Mr. Rusin, Attorney Rusin. I reached out to the original creditors, and they stated that my account was given to Midland, and that's where my account's set. Now, however you guys transact the assignments on collectors end, that's not my specialty. That's not my profession. However, that debt was, and as of this debt, my checks are not getting garnished, so it's paid in full. There is no remaining of $89 because it has already been taken out. And moving forward, for the record, Your Honor, if they can just, what I've been requesting and asking is a debt of validation. I'm asking for the payment history. I am asking for a signed copy of the signature with the contract of my signature. I'm asking if there was any insurance claim. These are my rights to ask. You guys, LVNV, should provide me this information. Now, the debt has been paid, but for the record, Your Honor, for my records, may I have this information?
All right, guys, we are switching gears to Florida for a masterclass in self-sabotage. We have a defendant facing serious charges who is offered the deal of a lifetime, a program that would wipe his record clean. Instead of saying yes, he plays the sovereign citizen card, arguing about jurisdiction while his lawyer looks on in despair. The judge realizes this man is his own worst enemy and revokes the easy way out. If you enjoyed this madness, don't forget to like the video and subscribe to the channel, and we will see you in the next video.
The central issue addressed by the motion in this matter is a motion to try to set aside a judgment that was entered by default in this matter. There would have to be a showing of good cause and a meritorious defense. And I've read the motion, I've listened to the arguments. I don't see a showing of any meritorious defense to the claim. Moreover, obviously, sickness would constitute some basis for showing a good cause, but you have to have both items, good cause and a meritorious defense. The whole notion of backtracking in this case prior to the entry of the judgment and demanding documentation of the debt and so on and so forth, none of that is relevant to the motion to set aside the default judgment. It's just the default judgment, you have to address the issue of whether or not there's a meritorious defense and affidavit to support that. And there simply isn't. And for that reason, after further reviewing this matter, for that reason, I don't see a basis for setting the judgment aside in this matter. It does appear that the defendant is entitled to a satisfaction in this matter, and that should be forthcoming from the plaintiff. If it's not, then the defendant may present to the court an application for satisfaction. I saw that there was something presented with the motion, but that was not in the form that is required post satisfaction of the judgment. That was a form addressing satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out. I do wish both sides well. Good day to you.